we can cater them to what the individual needs are as we begin to develop this program. I want to do a couple of quick housekeeping things, and first of all, thank the Center for Collaborative Journalism for both sponsoring and hosting this event, from the folks at the Telegraph and all the work that they've done to help us put this together and to provide this venue. I think this is a great venue for this kind of thing, and I'm really glad that we're able to take this resource. And Obi, I was just thanking the Telegraph.
Good, say it again.
And the Center for being able to host this event for us. Also, we're really indebted to the Georgia College Press Association. And Jennifer logistically took care of so much this morning because I hit that wall at the traffic accident down in Adel. And she got here and got the room opened up and got it arranged and did some very necessary things. So we're really glad to have the College Press Association join us with these symposiums because honestly, we've got to incubate young journalists who have the right sensibilities and sensitivities. And Georgia, for those of you that don't know it, probably has the best college press association in the United States. And I strongly feel that. And if you are a working journalist and you have not taken advantage of the Georgia Press Institute in Athens, you're really missing out something. That is a great event and great training, and Holly's always there. So that makes it even better. Let me tell you a little bit. Let me tell you a little bit very quickly about why we're here and what we're doing. First of all, those of you that are in the room are a microcosm of people across the state of Georgia that have a vested interest in open government and transparency at the local level. And we'll talk more about this later on, but this is an eclectic grouping of people, some of whom are just people who are passionate about their communities, some people that are truly activists in their communities, some people who are working journalists, some that are student journalists, and some who are government officials or elected officials in local government. And that is great, that all of those stakeholders come together for a common cause, and that is the good operation of government. Georgia is very, very fortunate to have Holly Manheimer here and the First Amendment Foundation. And I'm not going to do like one of these very long introductions, but let me tell you, there are two people in Georgia that are the leading authorities on what the law says about the Open Records Act and the Open Meetings Act. One of them is not here. That's David Hudson, who's the General Counsel for the Georgia Press Association. And the other one is Holly. You may not always find the answers that you're looking for. And you may not always get the help you think you want and need. But if you want to know what the law says, Holly is that resource. And when we formed this partnership, I was just real excited to be able to have someone of her weight and expertise to be able to provide the kind of information that just ordinary, everyday citizens want about how government ought to operate. And I want to say this too, very candidly and forthrightly. Those of us that are involved in transparency, in the Transparency Project of Georgia and the First Amendment Foundation, we are not against government. We are for citizens. And this is not some kind of anti-government movement. I could probably say that government is a necessary evil, but I'm just going to tell you, I don't think that government officials are evil. I think sometimes they are misguided. Sometimes I think they are mistaken. And a few times I think they are corrupt. But I think by and large, local government officials, and especially people that work in the halls of government, employees of government, want to do what they're supposed to do. But sometimes there's a lot of misinformation. And sometimes that misinformation comes from all the wrong places. Holly will give you accurate legal information. Not only as the first and the only executive director of the First Amendment Foundation, but as truly one of the leading First Amendment and open government lawyers in our state. So, agree or disagree, she's going to tell you what the law says. The way today is going to look, this morning, Holly is going to spend some time talking about open records, and then we're going to transition and talk about open meetings. We would like to, in these morning sessions, to keep discussion to a minimum, because that's what we're going to do in the afternoon. Now, if you have a specific question about a specific thing that she has said, for clarification purposes, of course, we want to be able to make it that interactive. But for larger discussions, for conversations about the things that you're doing or going on in your community, that's what the roundtable is designed for this afternoon, and Obi's going to be joining us for that, and Dr. Miller is going to be joining us for that, and we'll have some great conversations this afternoon regarding all those kinds of things, so we can get through this material with as much dispatch as possible. If we can kind of keep any questions for this morning's session very targeted and specific to the exact things that are being covered, that'll help us expedite it. So, with all of that being said, Holly Mettenheimer. By the way, it's IE, not Y.
That's our biggest problem. Thank you. And I probably will just work from talking to you as opposed to a PowerPoint or other things. Let me also apologize in advance if some of this material is too basic for some folks who I've known and worked with. Apologies. Of course, we're all starting and all this is important. My thanks, of course, to Jim, who's a true believer in fighting the real fight, enables people like me to do the legal work that unfortunately is required in open records and open meetings. Okay. Who am I? Most of you know me, Holly Manheimer, Director of the First Amendment Foundation. I'm a lawyer, and I've spent most of my adult life working on these issues, meaning open records and meetings in Georgia. Where to begin? Let's start with open records, and let's go over in the next half hour a nuts and bolts of how the Open Records Act works in Georgia. First of all, we know, every one of you in this room knows, that books, maps, papers, all kinds of data, any document, any information generated in the course of public business is subject to the Open Records Act. I don't think there's a dispute. There shouldn't be a question about that. And let me tell you why that's a new and an important context. The Open Records Act, this version of the Open Records Act that's been around in Georgia, has been around probably since the 50s, 60s with various tweaks. In 2001, when Governor Roy Barnes was elected, who represented, Governor Barnes used to and may still represent the Marietta Daily Journal, he was interested in media work, and there was sort of an overview. The next overview, rewrite, came just in 2012, and most of you might remember that. Effective April 17th of 2012, we have a new set of open records and open meetings laws in Georgia. And why I bring that up at this juncture, after I say books, maps, papers, all information generated in the course of public business is subject to the Open Records Act, because for the first time in 2012, the word email showed up in our current version of the Open Records Act. And I am that nerdy that I have spent time reading the text. This is the House Bill 397 that in 2012 led and now is the current version of the Open Records Law. I went back and I said, is that possible? We've been taking the position since '01 at least that email and electronic communications are subject to the Open Records Act, but it was never in the law. So in any case, in 2012 was the first time that this concept of email, text, electronic communication, all those other things made it under the umbrella of the current Open Records Act. So when we talk about nuts and bolts and how to procure public information, public records, it's a new game in town. We're not talking about an 8.5 by 11 piece of paper anymore. Not only are you getting and requesting data by way of email, and getting data by way of websites. Email itself is specifically referenced in the Act. Texts, no, but we take the position, all open government advocates take the position, although I get an awful lot of questions about whether text messages are covered by the Open Records Act. The answer is yes. In short, and I don't think we want to spend a lot of time on it, your rule of thumb is any piece of information, any data, any writing, any info generated in the course of public business is subject to the Open Records Act. Rule of thumb, easy, remember it, push back when a public official says something is not subject to release. So with that said, what is the process? More so than in open meetings, open records, it's kind of a formula. Anybody know what FOIA is, Freedom of Information Act? Federal Act, right? Everybody's heard of that when we are looking for information from the federal government. Open Records Act deals with state, county, and municipalities. So if you want information from the federal government, you use FOIA. If you want information from the state, the county, or a municipality, you use Open Records Act. Why I bring that up now is though, our state's open records request model, a copy of which, or a sample, I think I might have written it, I don't know, it's kind of old, is in the back of this book in Appendix 1, a model open records request. It's modeled on a FOIA request, and it is the triggering point. It is how one, as a citizen, starts the process of seeking information. You file what's called an open records request. How many folks in this room think that you can still ask for records verbally? May I have my police report, ma'am? Or do I have to write it down like this says? How many think verbal requests still stand? How many think don't? Law still is in Georgia, based on yours truly. Perhaps I take too much credit. I really don't know as much as you think I know. I put down my foot in negotiations with the Attorney General's office, and I said, no way is there going to be a First Amendment Foundation and a Transparency Project in Georgia if we don't allow verbal open records requests. Because we're all in this room because we want to learn how to file better open records requests, that triggering thing. A lot of folks don't know how to do it. A lot of folks, all they know is to go down to the county city council office and ask for the minutes. Anyway, so yes, the starting point for open records is an open records request. It can be verbal or written. In Georgia, I advise you to write it down. The remedies, to the extent that we have remedies in Georgia, are better if you write it down. You also want a memorialization. You want a something to keep in your notes. Use my model, I think it's Appendix 3 in this book. We've got stacks of books up there. Use my model to start, but take liberties with how you want to send it. You can send it on a paper towel. You can send it on a piece of toilet paper. You can mail it. You can fax it. You can email your open records request in. Just keep a time and a date, because the most important thing, perhaps one of the two most important numerics in the Open Records Act, is the time in which a public official needs to respond to an open record request. Who knows the answer to that? I bet everybody does. 3 days. I need more clarity. Is it 3 business or 3 calendar? 3 business days. 3 business days. So, I told you that the triggering, the impetus process for the Open Records Act starts off by way of an open record request, be it verbal, be it written. The public agency has 3 business days in which to respond. By way of background is that a lot or a little, different states, some states have a reasonable, they don't even have a numeric, they just have a reasonable time to respond. You can see why that would be bad. There's no outside numbers. I think Texas has 10, I can't remember. You might know North Carolina, I can't remember. I've never, in my 18 years of doing this work, I've never grumbled about the 3 business days, and I know I'm getting all these smiles and smirks from around the room, because what public agency really responds within 3 business days? But we'll get to that when we get to remedies. But the point is, inside of 3 business days, the public agency must respond. Which begs the question, what are they supposed to do in 3 business days? Who's here from the city of Atlanta? No one, that's interesting. They were among the biggest offenders who used to, inside 3 business days, this was classic. I actually started to giggle when I saw one of those responses. They would send back quite timely, inside of 3 business days, on proper date. Thank you very much for your request. Now, we could all talk and laugh and crack up about why that's bad, but in 2001, we tried to fix that, because obviously that was an inadequate response, and we looked, and when I say we, I was just one of the people at the table with the Attorney General, with all the law enforcement, with the hospital authorities. I just kept jumping up and down and making a fuss, saying I'm gonna walk out of the room, when I thought, to the extent I know anything, that the public's interest was being compromised. So when I say I helped write it, I don't know, hopefully I did some good, and some good things and some bad things passed in 12. But, I just lost my train of thought. What am I telling?
3 days.
3 business days. So what are you supposed to do inside of 3 business days? There was some effort to clarify what it was, both in 01 and 2012. And this is how I remember it, particularly for folks who are starting out. 3 choices in 3 business days. Choice number 1. Yes, the records are subject to the Open Records Act, and here they are. That's the answer we all want, the yes response. Yes, the records are subject to the Open Records Act, and here they are. Choice number 2 inside the 3 business days. Yes, the records are subject to the Open Records Act, subject to disclosure. However, they are not available right now. They are in archives across town. They are unavailable. It will take us a while to get them. So the second response is yes, and an estimated timetable of when they will be available. So that's what I call your mid-level response. Yes, and I'll get them to you in 10 days, I'll get them to you in 14 days. Not yes, I'll get them to you in 5 years. Not gonna work. Yes, I'll get them to you in a couple weeks. Third choice is the answer we don't want, the no. No, the records are not subject to the Open Records Act, and the public agency is required to cite the section of the law, the code section, typically under Georgia Code Section 50-18-70 and following exceptions. A basic exception, for example, the medical records of a public employee would not be subject to release, and if the public agency is telling you no, you can't have them, it has to tell you under what code section they're saying no. So to review, 3 business days is the time for a public agency to respond, and they have 3 options inside of the 3 business days. Yes, here are the records. 2, yes, here the records are subject to release, I'll get them to you in probably 2 weeks. 3, no, the records are not subject to release under XYZ code section. Something new that popped in 2012 is rolling production. The idea that if a portion of the records, let's say you're looking for a personnel file and some of it's ready right now or accessible, as soon as it becomes available, that should be made, even if that should be made available and produced regardless of whether or not the rest of the material is going to be forthcoming. Now what about the basic record? When I walk into the police department, and I always have to laugh about police departments, who's here from Gwinnett? I won't identify who, and frankly, I can't remember who it was.
We probably remember.
I got into it with the public information officer of the police department, and she told me I don't know anything about the Open Records Act. I said, okay, that's fine. I mean, it was sort of one of those moments when I was like, okay. What if you want an incident report that is probably readily available? If you walk into the police department and it's there, the agency can't wait the 3 business days just because the statute says up to 3 business days. It's got to be released if it's readily available, and it's got to be released now. You can't. In other words, in short, a public agency can't just wait because they're allowed 3 business days. If it's there and it's ready, it needs to be produced. I know all of you are thinking, yeah, what if you don't get a response at all? And we're going to save that question till the afternoon because that's a lengthy one that everybody, including me, don't forget, I use the Open Records Act in my private practice to get records. So I've been Stonewall as well. So, but in any case, that's the way the Open Records Act is supposed to work. And I understand that it doesn't always work that way, but the 3 business days, and the 3 choices inside the 3 business days, rolling production, stuff being made available as soon as it is ready, and an agency can't use the 3 days to hold out on you. All right, what happens though? What's supposed to happen? You know, it's a case I almost litigated about a decade ago, the idea of access versus copies, which is going to be our segue to costs. What does our Open Records Act really give us the entitlement to? Does it give us the right to copies? Does it require a public agency to mail things? Or is it an access statute? I'm curious because the answer isn't exactly so clear in the law. How many think it's just an access statute, meaning you get to view record? Just show of hands. How many think it's an access and copying statute?
I mean, what to think?
I'll wait for the rest of the auction. She gets copies and
Yeah, I mean, you know, it's something that I've actually contemplated writing some kind of legal article on, because it's not as clear, but essentially the Open Records Act in Georgia was written as an access statute, and some, you know, the case I almost took, the great thing is I remember nothing, which is helpful in many ways, but it was a woman in South Georgia who did an open records request for something in North Georgia, and the public agency in North Georgia said, sure, come on up. Records are here ready for you to look at. So I thought it was sort of a fascinating question. I mean, it still is the question, does the agency have to copy the records? And we'll talk about what to pay for. And that's something also that I might want to save for the afternoon, because I mean, no one ever wants to hear your question. I love telling clients how interesting. Nobody wants to hear it's interesting, because that means there's no answer. But it's, I mean, it's written as an access statute, meaning the public agency is required to make the records available. Most public agencies are going to not want to see us, they're not going to want to deal with us, they're going to want to send us copies. And that's why the copying and the fees and all that kind of stuff, which I'll talk about next. But keep that in mind. One of the new things from 2012 that I like very much is you get to bring in your own phone, snap pictures. All of that's sort of in the statute now. I mean, it was always sort of that was the way some people did it, but it's pretty clear you can bring in your own copying device now, and you can make your own copies, and you can do copy as you like. But traditionally, certainly in Georgia for the past few decades, and most other states, there has been a schedule of costs and a copying mechanism. Who knows what it is today in Georgia? How much can an agency charge per page?
10 cents.
That's correct, up to 10 cents. I might point out to you that you might ask for the cost to be waived, and many public interest organizations do. What was the law until April 17, 2012? What was the per cost per page?
25
Up to
cents.
25 cents. I bring that up to you for a something where you could see that the media, who is very interested in open records and meetings issues, its interest often diverges from the public's interest. The media made a trade at this negotiating table in 2012 for the 10 cents per page. The media said, look, Kinko's, you can copy documents for 3 cents, so we don't need it up to 25 cents per page. But they traded, and so when I say they, we, the trade was redaction. Now a public agency allegedly can charge when it redacts the names, social security numbers. I wasn't happy about that. In any case, that has been one of the very public alleged triumphs of the media and the public interest, that the cost per page is down from up to 25 cents per page down to up to 10 cents per page. The point is, you will get, and you should ask for, a fee estimate, and it should say to you, pages times up to 10 cents, and then reasonable search and retrieval fees based on the hourly rate of the lowest paid person capable of doing the work. Meaning you can charge for some staff time in getting the records out. Does that mean county attorney time? Not to pick on Gwinnett, but great case from the 80s out of Gwinnett County where it was Trammell.
You can pick on Gwinnett, we do.
Was Trammell one of your officials in the 80s? Trammell? Case was something named.
There's a lawyer, Trammell.
Okay, yeah, I think his name is in the style of the case. Some agency in Gwinnett was charging county attorney time to calculate the rate of staff time and Supreme Court said that's ridiculous. It's gotta be the lowest hourly rate or the hourly rate of the lowest paid person capable of doing the work. So we're talking about $13.50 an hour, $15.50. So the formula, I'm digressing, is up to 10 cents per page plus reasonable search and retrieval time for staff time based on the hourly rate of the lowest paid person capable of doing the work. And the first 15 minutes of search and retrieval time is free. Now that concept of it being free goes back to my idea, if you walk in and you want a record and it's readily available, not only can the county not wait its 3 business days, it's also the idea is that it's not gonna charge you to hand you a record through the glass window. Are these things working in principle and practice? Perhaps not, which is why everybody is in this room. But that again is the way the law is supposed to work. Let's digress for a moment and talk about email, web access, and things like that. As I mentioned earlier, in 2012, it was the first time Georgia's law ever really had some significant recognition of how business was really being done. Ma'am, come on up here. You can stare right at me. I'll move the law. In 2012, it was really the first time that the law really talked about electronic access, web access. Let me get your opinion on this, because I think it's an interesting question. When you send an open records request to Putnam County, where I live now part-time, yeah, I told you that.
Yeah, I talked to you about that.
Yeah, was tired of DeKalb. Can the public official, can the custodian of the records say, it's online, you can get it there, or do they have to make some affirmative action? Do they have to do something to require you, or to comply with their obligations? Who thinks, can you see I'm interested in everybody's opinion? I want to learn how the new law is working. That's why I'm asking all these questions. I want to see what worked and what is working and what's not. How many people think it's enough for a public official just to say you can go to the website?
Let me make a comment on it. I think it's great if they do that, but if it was somebody like my father that wanted something that doesn't have a computer, it's a whole different thing.
And that's actually, I'll tell you this, you keep thinking Jim thinks I know so much. I was like, yeah, sure, that's a good response. Well, the powers that be, the lawyers who know much more than me, said, hell, what are you kidding? No way. You can make that as an option. You can say it is available to you on the website. However, if you'd like me to produce it, I can get it to you now in an estimated timetable. So it does seem to me that it's one option, and I think it is good as well, the more agencies that use websites and such. I will say that there's a general background in the Open Records Act that talks about where the public agency can make records available electronically. It should, so there is a push for public agencies to do that. It's not always happening, but it's certainly a push. But the other change that may or may not be useful to those people in this room that was a big deal for bigger media like the Macon Telegraph and such, our database, access to databases. there used to be some great stories, and for those of us who do this work, where a sheriff in South Georgia said, yeah, come on, you can have access, here, sit down at my computer. Well, nobody knew how to work the program that he had kept his data on, and so it was pretty much, and that was obviously not real access. So there was a push and a stress that the law would say access needs to be reasonable access, real access, and there's this thing in the law that's a good thing, and I'm gonna come back to databases, that says public agencies do not need to create a record where it is not already available. But so if you ask for something on a database, and it would only require one keystroke for the public agency to manipulate the data, there's some clarification now in the law that as long as it's not a new program, but it's just putting the data in the format that you want, that the public agency needs to do that. That's not considered creating a new record. And if you want to talk more specifically about that after lunch, we can. There's a whole code section, it was actually written by some of the database editors at some of the dailies around the state that talked about that. Because that was a real stonewalling tactic where folks would ask for a list of names, and the public agency would write back, well, I just have a database, it's got everything, so I don't have a document with just the names. So you see how, in any case, let's see, I only have 10 more minutes on Open Records Act, so let me touch to you. I could talk about it all day, I could put you to sleep about it all day, but let me talk about three more topics, and then we'll turn to meetings. Custodians of the record. Remember I told you, and you know, that the beginning process, the trigger, the impetus, is you file an open records request, and that starts the process. Well, there's always been sort of a vagueness in the law. Who does that open records request go to? And I would always say in a fallback position, right to the chief, right to the police chief, or right to the city manager. The 2012 version of the law, again drawing on FOIA, the Federal Act, instituted this idea of a designated custodian of the records. And I don't know whether I think that's a good thing or a bad thing. And I was talking with someone about that before we started. That means that there is somebody in every public agency designated to be the person to respond to open records requests. Now, on the one hand, that could be a good thing, because somebody allegedly knows a lot about open records requests. On the other hand, as the question was put to me, what if that person is out of the office? The way it's supposed to work, and I've been on all these technical discussions, well, you could put something on your email saying, I'm out of the office to this day, and go bring your request to so-and-so. I think it's not as simple a question. I don't have data yet. I don't know how many agencies have decided to designate a records custodian, but to the extent that your jurisdiction has decided to do that, they need to publicize it. In other words, you need to put on the county or city's website who that person is, how to reach them, this or that. You can't just say there's somebody and not tell anybody who that is. But I'd be interested in hearing in the afternoon how many jurisdictions all of you are working in, and whether or not there have been public records custodians designated. Because I was unsure in my mind when discussions about this took place in 2012, whether or not that was a good thing. So let me roll back, talk about one more topic, and then talk about what you mostly are probably here for, remedies under the law or lack thereof. So the process is simple. I shouldn't use that word. We know it's not simple. It's supposed to be simple. All public data is subject to the Open Records Act and release, with certain exceptions. We start the process by way of an open records request. There are 3 business days in which to respond, and 3 choices for the public agency to respond: the yes in an estimated timetable, the no. Public agency is able to charge up to 25 cents per page for copying, plus reasonable See? Up to 10 cents per page, see, remember, doing this too long, time to retire. Up to 10 cents per page, plus reasonable search and retrieval time. We talked about custodians of the records. Let's pause for a moment when you get the no. When can a public agency say you can't have the records? And to be fair, there are quite a few instances, more than I care to admit, in Georgia's law where public information is not subject to release. Some things make sense. For example, it's embarrassing that I know the numbers, excuse me, under 50-1872A, which is the list of exceptions for what's not subject to release. Number one is records that the federal government says is closed. State can't release. Some are obvious. Here's an obvious one, Social Security numbers. When I started this work, actually Social Security numbers were closed by federal law, but opened by state law. And I remember I was down at the General Assembly, and some committee member, rightly so, I was testifying, well, we need to keep Social Security numbers open. And he looked at me, I said, okay, I know I'm a single woman, I live alone, but anyway, since that time, Social Security numbers in the state are closed, analogous to the federal law. Other things, medical records, credit card information, other personal information of public employees, and the list goes on. I would urge you to take a copy of this book, because in the back, I reprinted the entire law, and you will see that the list, it's grown, unfortunately, since I started the work, which means maybe I'm doing a bad job. You can't, we've added, lobbying groups show up understandably at the Capitol and say, oh, we need an exception to close information to X, Y, and Z. Carpool records, I mean, sometimes, it just, unfortunately, I've been there enough now when I'll at least make my case. I sometimes say, committee members, do we really need an exception for this particular narrow group? But that's how the list of exceptions for data that's not releasable has grown. DFACS, Department of Family and Children's Services, some legitimate reasons for closure of their records, some not. Court records is a whole nother thing to discuss, but when I talk about everything is subject to release, our courts in Georgia have consistently said the general rule is openness, exceptions to release, meaning these 1 through 25 or so, whatever they are, should be narrowly construed. Jim's going to talk about that from a policy perspective. But the point is, we do have a list of stuff that the agency legitimately can withhold. We could talk more about some of those specifics after lunch. I know there's a group from Cobb here that wants to talk about the Braves negotiations and such, and whether that information should have been subject to release. And I'll tell you right now that I certainly think more of it should have been released than had, but we'll save that. But I wouldn't be honest if I said everything is subject to disclosure. For better or for worse, every state in the country has a list. Ours is no worse or better than any other states, but some information, some public information is not subject to release. So the question you're all here for, I think, is what do you do when the Open Records Act doesn't work? I don't know. What do you do?
Keep working.
Tough question when the open records process breaks down, and it's something that you can certainly quote me as saying this, and it's something I've said for 18 years. I think what we need in Georgia is prevailing party attorney's fees, so more lawyers will take these cases and on a contingency basis, and the law sounds like it says that now, but it doesn't. Here's what the law says. Here are the minimal choices. And remedies are weak, and Mr. Owens and I disagree on that, our Attorney General. He keeps telling me how great the remedies are, and I keep saying, sir, sir. I said, I've never run for elected office, but I've been around the state as much as you, talking to citizens groups, and the law isn't working. Okay. Let's start with, something that came into the law in 1998, modeled on Florida. We didn't really have any remedies, so in 1998, the law changed to allow us to call the Attorney General's office and to use a mediation program of sorts. Here are the bad parts of it, and then here are the good parts. The bad part is there's one assistant attorney general there who has 15 jobs in addition to open records to deal with. However, the idea behind that was nobody local in your jurisdiction is going to address the issues, so let's get a state official outside the county. So there is that program in place. One can write to the Senior Assistant Attorney General. Many of you have tried to, I believe, Stefan Ritter, that's a gentleman, Stefan, and last name is Ritter, and I can give you his email address. What they will do is send a letter to Putnam County Commission that says essentially, we've received a complaint against the Putnam County Commission for not releasing records. What's your position? Then, of course, the Putnam County Attorney's gonna write back, so we're gonna get into, I'm sure you all know more about whether this process is working or not, but that is available. The next option,
Can I make a comment about that?
you may,
It would be good if the Attorney General also wrote the county commissioner so they know what's going on. Because obviously they don't.
well, I'm not sure, I agree that they don't know what's going on, but the more.
They say they don't. They
Right.
ignore it.
The more, but anyway, that program is in place. Before I talk to you about litigation, here are some other things. I personally, yours truly, now please not everybody write me tomorrow, because I'm gonna take off tomorrow, but wait till Monday. I'll write a letter, but I can't be your lawyer, obviously. I will write a similar letter that has worked on occasion. Once I was able to stop a meeting, I was so proud of myself. I will write and say, and my letterhead has just about every major media outlet on the right, and I'll say, look, we've heard that your practices don't look good. What's the problem? You're not releasing records, you're taking too long, you're charging too much. And the idea with that is more than just you are asking, it's Holly and somebody else, Holly and Jim and other people, there's outside people looking over it. So that's an option that happens. Some of you, Jim, Obi, others, media, have even more power. Write a story about secrecy. I am not, of course I'm not a journalist. I don't subscribe to the thought that covering transparency is a conflict for the media. I think some media folks subscribe to that theory. Again, I'm not a journalist, I don't think so. Short of all those perhaps ineffective, perhaps effective, sporadically useful remedies, what do we have? Not much. Number one, a lawsuit in the Superior County of where the alleged violation takes place. Now, is it practical to sue for the minutes of a meeting? No. Who can afford it? Not I. The point is, Superior Court litigation is an option. It's the most tangible option on the books right now. It's there. You know, if you, are there any lawyers in the room besides me? You know that there's tons of case law in every other jurisdiction. There's this much case law on open records and open meetings. Case law meaning very little litigation. The only entities that could afford to litigate these things were the big media change. So you get it's obvious that litigation isn't a practical or effective remedy, but it's certainly there. And one kid, and he is a kid, he's trying to get into law school, or he was, did a great case against the city of Atlanta on an open meetings violation. Matthew Cardinale, if anybody knows him, did it pro se, did it himself, and I filed a couple of amicus or friends of the court brief, but he did a great job in trying to make the City of Atlanta City Council conform on open meetings violations. It can be done, but it's not easy and it's not practical. The other remedy that the law contemplates is even less so, and David Hudson and I, we had a big laugh once. David Hudson is the gentleman referenced also, who probably taught me everything I know, and some others did as well, about how many criminal prosecutions there were under the Open Records and Meetings statute since the 60s, and I think we counted 4. Yeah, I mean, so the idea is that the solicitor, state court, or the district attorney, it's unclear to me in the law, does have jurisdiction to cite the public official for wrongdoing. There's somebody in the room here who was gonna come and talk to me about what willfulness means. I don't know who, and somebody sent me a package overnight in the mail to talk about Macon and Bibb County and willful violations. The point is for these criminal prosecutions to cite the public officials for wrongdoing, there has to be some showing of malice, willfulness, intent. That also crops up in the civil, a civil piece of litigation is for money essentially, and criminal is for jail. No local district attorney or solicitor is gonna cite their next door neighbor, their boss for wrongdoing. So I would say be aware of criminal violations. I wouldn't count on them. There is something new though, that I actually have a private case that I am trying to litigate, that I'll let you know if it works. So something in the law said, and I may lose on it, so that won't do us any good. In addition to the Attorney General suing, citizens now can ask for civil fines in the context of other litigation. And in federal court on a case, anybody here from Forsyth County? That woman who got thrown out of the Cumming City. Yeah, I'm representing her in my private capacity. Again, private lawyer versus this, although the First Amendment Foundation is helping on, just because the Attorney General won his lawsuit, because he's not going to litigate every dispute, is she shut out of her own remedies. And I'm on a motion for reconsideration with the federal court about that very issue. Just because the Attorney General won, does that preclude a citizen also from this idea of civil fines? Even if I win though, I don't know whether that is $1,000, $2,500 a real threat to any public agency. We're paying it as the taxpayers. But in any case, move on, although I'm gonna ask you to say a few words so I can have my coffee, and then we'll move on to open meetings. I leave you with the thought that I am unhappy too about the remedies for open records and meetings violations. I don't think they're good, and again, this is where Mr. Owens and I have serious disagreements, because he keeps telling me the backed his teeth, and I literally keep jumping up and down. Are you kidding me? But that aside, there's more work to be done on that. Anybody interested? But I don't have a lot of good news on that, other than people like Jim fighting the good fight, and others trying to do enforcement. You want to say, or why don't we do a couple questions?
Sure,
and then
sure.
meetings, so I can.
Yeah, questions relative to records, to the materials that we covered.
I have a question. In the law, it says within the 3 business days that they have to reply to you. I live in Paulding,
Airports.
and the airport authority, I put in my email request on one day, and on the 3rd day they respond to me via mail, so I don't actually receive it to the 4th or 5th day, but the actual documentation is dated the 3rd day. So they're saying, and I've questioned that, and they're saying that they have responded within the 3 days.
I think even though I agree, and I would be very dissatisfied like you, they're probably okay on that. It's unfortunate, particularly since you and I both know they could have emailed, scanned in and emailed the stuff, but yeah, as long as they do it inside of 3 business days. You know, one of the questions that I deal with all the time as an agency the statute's written technically 3 days from when you mail it. That's not really practical. A lot of agencies are dating their response from when they receive it, but I do think in your case, they're okay on that, I'm sorry.
Yeah, I did too. Got another one. You need to add another note to that one. That they are not in possession of the records as per requested.
That's a good question. Well, they're all good questions. That's something that I have struggled with. To extrapolate, the question is, so you send your request to the agency and they say, and you know the records exist, but they say it is not in our possession. I think you can handle that in any number of ways. In your case, did they tell you who has possession of it?
They say it's not in their possession.
There are no records responsive to your
And
request.
That's
There you
go.
probably the
That's
most
the word.
typical response that you're going to get. And you're gonna find out a lot of times, it's not as much about the record as it is about the request. But they will look for technicalities, they will look for loopholes, they will look more oftentimes than not for a reason why there's no record responsive to your request. Now, I'm not giving you the answer that open government advocates want, or the answer that media wants, or the answer that residents or citizens want. But what I'm telling you is that we have got to understand that our intent is to get the record. What you're after is the record. And we should never do what we do. And I'm not saying that anyone sort of has this mindset, but we should never do what we do for the purpose or the intent of saying gotcha. And it's not a cat and mouse game. But the intention is that the record is a public record and we want access to the record. A day or two delay should not happen. The response should happen within the mandated period. A production letter is not a record. However, we've got to make sure that we pick our battles and fight the good fight and create a culture of openness. And that's one of the reasons, by the way, that we want to conduct these symposiums across the state, because you guys are the foot soldiers. And you need, and we're going to talk a lot more about this as the day develops, but you need to help incubate this culture and this environment where there is an expectation that those records will be produced and that they will be produced in a timely fashion, and they'll stop looking for the loopholes. But we're not there yet. We do not have that culture in Georgia, and we don't have that culture in most of our communities. I do need a volunteer, but there's a few caveats that go with volunteering for this. First of all, you can't be a current or former employee of mine. And secondly, you've got to, you can't be involved in the Transparency Project or the First Amendment Foundation. And third, you've got to have a very high personal ethical code. So, who wants to volunteer? Want somebody that's very ethical? Okay. What I want you to do is I want you to look at the contents of this envelope, shield it from your neighbors there who are all really nosy and like to look over people's shoulders. Eventually, it'll everything be disclosed, and at the appropriate time, which is much later, I want you to do what you think is ethically correct based on the information that you read in the envelope. Okay, we are going to transition the discussion into a discussion about open meetings. And I will tell you that Georgia does not have the best open meetings laws in the nation, nor does it have the worst. But I would suggest to you, and it's something that Holly has already alluded to, that our presumption as citizens should always be a presumption of openness. Whether we're talking about records, we're talking about meetings, we're talking about things that people want to take in executive session, any resident, any citizen in the state of Georgia should always presume that everything that government does and every record that government holds is open, that it is public. There are exceptions, but the exceptions should not become the rule. And I would suggest to you that we have a culture in our state and in most of our communities where the exception has become the rule. And the onus should always be on government to justify the exception. In fact, they are required to. So, sometimes when Holly gives you the legal opinion, you may not like it, but it is what the law says. And sometimes when we tell you the reality or the gravity of the situation that you're involved in, it may not be the satisfying, the emotionally satisfying answer, but it is the reality. I believe that there are tactics, tools that we can put into place to create the right kinds of sensitivities and sensibilities in local officials. But it's not going to happen in a day. Hopefully, as we go around the state and do this with groups like you, we can create an army of people that are equipped with the right armaments to be able to help build that culture of openness where the expectation, not just of citizens, but of government at all levels, can be that everything that government does, every piece of business that government does, and every document that government holds belongs to you. Okay, now Holly's going to talk about meetings.
All right, so we start from the same general principle that the meetings of all government agencies are subject to public attendance. My favorite example is the school board. What others? I mean, what other common meetings are you guys having trouble getting into?
Board of Commissioners.
Really? What county?
That's why I basically.
What I suspect is that you're not having trouble getting into the meetings, is that you are having the business is happening before and around the meetings and outside the meetings.
This is Noah's Ark.
Yeah. So basically, open meetings in Georgia there is no federal equivalent to the Open Meetings Act. There's something called the Federal Advisory Committees Act, but I don't even know what that is. But there's no equivalent like FOIA is to the Open Records Act. But it says that the meetings of all public agencies are subject to attendance by citizens. I will point out that all the agencies covered by both the Open Records and Open Meetings Act is contained in the definitional section of the Open Meetings Act. To a certain extent, for your guiding principles, you want to start with open meetings. But let's get down to the nuts and bolts. How do you know about a meeting? What's the concept? Notice. 3 types of meetings in Georgia. One I wish we never had. Our regular meeting is the first type. In fact, in my office building in DeKalb County, I think the Economic Development Authority meets in my building. So I have noticed that there is on the marquee always something that says for the regular meeting of the Economic Development Authority, first Monday of every month at 6 p.m. in room 6. That is sufficient notice for a regular meeting. I don't have much to say about a regular meeting unless somebody has complaints, but it is very simple to notice a regular meeting, because typically it would always meet at the same time each month, each week, and there would be a standing notice and no requirements that there would be anything else. The bigger problem in the Open Meetings Act with notice is for your special meetings, and then dread of dreads for this concept called emergency meetings, which I hate and I wish never existed, and it's been a disaster, and we'll talk about that in a second. Let's start with special meetings. What is a special meeting, and what kind of notice does one need for a special meeting? Special meeting, as you know, something that comes up that needs to be addressed outside the contours of a regular meeting. They have to meet for some other reason. It happens all the time. What is the notice requirement?
24 hours.
It's 24 hours in advance of the meeting. There also is a provision that the public agency needs to notify the local organ of the county when that's happening. The question you're about to ask me is, what if the meeting's on a Thursday and the organ publishes on a Wednesday? I know, I've dealt with all these questions before. I think we're out of luck. 24 hours notice in advance of the special meeting. I don't know that I have much more to say about that. I know that that issue is, and special meetings are rife with problems, particularly in Cobb and others, and we'll talk about that at length, I'm sure, during the afternoon. The third class of meeting is a terribly scary concept, and I hope that none of you in this room ever have to deal with it. An emergency meeting. That is a concept, the third tier of meeting, contemplated by the statute. It's OCGA 50-14-1, and it essentially gives free rein for the public agency to meet when it wants. The design and the reason for this meeting was not because the bond has come due. That's not an emergency. What the emergency was a broken bridge, was a tornado. That is the only reason, and I suspect if we have a good case, I'll take it. Maybe, don't quote me on this, maybe pro bono, because I hate this concept of an emergency meeting, and I think it's abused, and none of us in this room, the way the statute was written, should have ever deal with an emergency meeting. Essentially, there's no notice required, essentially. For these alleged emergency, the public agency can meet, essentially, they just, is there even an hour requirement? I don't even remember. I don't think there is any requirement in the law. But it should only be used for something like a bridge breaking, when all the channels to the town are blocked, or a tornado, or a real emergency. And just about nothing qualifies. On a national level, the example that they give some of the scholars in this area is when there's an oil leak that is infiltrating all the water and children are swimming in it. That's an example of when you use an emergency meeting. But just for your knowledge, notice is the concept, how we learn about public meetings in Georgia. 3 types: your regular, which is notice on the marquee; your special, which is your 24-hour notice. And if you leave with nothing else today, you can remember that Holly hates emergency meetings and think they are really an abused thing of the law. All right. Another thing happens in advance of a meeting in Georgia. It is called an agenda. When does an agenda have to be made available?
Or as soon as possible, up to 2 weeks.
How about this for some great legal writing? I don't know why I didn't think to change this. This has been in since 2001, up to 2 weeks before. What does that mean in the law? I mean, come on. Yeah, sometime, but no more than 2 weeks prior to the meeting. The point is, and I don't, unless you tell me otherwise, I don't know that public agencies, most of them are making an agenda available. The point is, there's nothing on the agenda. So I think that's the bigger issue with agendas. So in the 2-week period prior to a meeting, an agenda needs to be available. Here's the problems that I'm aware of with agendas. You know, public agencies put them together, but what is on them? You know, there's always, is it adequate to have a standing closed session on it? I think no, but I know it's on every agenda, and I think in a litigation, frankly, I would lose that one. We would lose that one. But I know a lot of counties have a standing closed session on it for personnel matters or litigation or what have you. Here's the key, the only litigatable point, and litigatable means something that's got teeth when you go into court. What happens if something comes up during the meeting that is not on the agenda? How many, here, back to my hands, how many people think that the commission can discuss something if it was not on the agenda? How many, well, I know they do, but how many think you can't? Yeah, I mean, here's what the law says. It's in some of the reported cases. It says if an agenda item that becomes necessary during the course of a meeting to discuss, then it's permissible. Of course, you and I both know that, what does that mean? And it happens all the time, but there was some effort in the statute to try to put some caps on that and to try to make it a real working agenda. It's quite obvious if your property is gonna be condemned and it's not on the agenda, and somehow the the agency brings it up and it condemns your property and you didn't know about the meeting, so you weren't there, that's a problem, but that's the whole point of agendas prior to meetings. So in advance of the meeting, again, sorry to repeat, the notice concept, the agenda concept, so we get to the meeting. We discuss, they discuss, whatever they want. I'll ask you something that I would say may rank as the #1 question I get in the office. Do I, as a citizen, have a right to speak at the meeting? No. Anybody think citizen has a right to speak at the meeting?
I think you ought to have it.
Only if
Be
it's a
able
public
to.
hearing.
It's a public hearing. Any other thoughts on that?
You can get up and call them out if you know they're breaking the law and ask to be put on the record, can't you? If you know they're doing a protocol or doing something.
Yeah, I would love to say yes, I just don't want you to get arrested and then
What if they
my
haul you
board will
out?
fire me and then I can retire really, but no. Yes, within limits, you do want to call your council or your commission, but yeah, I mean, it's a great question about the ability of the citizen to speak at a public meeting. It happens not to be at all mentioned in the Open Meetings Act. It's a pure First Amendment right. What I mean about that, it's a speech right under the Georgia and federal constitution. It's the idea that we are allowed to speak. But the Open Meetings Act governs the actions and the speech and the procedures for the public officials, not for us. I will say that if you were grappling with that, because that comes up quite frequently, what a public agency has to do is equal time for both positions. There's got to be some kind of equity in terms of you can't let everybody for the condemnation speak and people not against. There's got to be some equity, the same amount of time, both positions, equal speech. I know, cob. But again, it's not really an open meetings concept, but I started bringing it up in my talks because I get calls, I'd say at least one a week, about do I have a right to speak at my public meeting?
Yeah, ours generally have, if you sign up beforehand, you have 3 minutes, whatever. I think that's fairly pervasive.
And how do they handle it if like hundreds of people want to speak for 3 minutes? Or how do
I think they arbitrarily draw a line.
We limit ours to 30 minutes.
Yeah, I mean, anyway, it's an interesting question, but again, it's not an open meetings question, but obviously it relates to, in the way that, let me digress for a second, record retention, which I didn't touch on, meaning how long a public agency needs to keep its records. It's an analogous or a concept that's tied to open records. This idea of citizen speech at a public meeting is kind of tied to open meetings. All right, you're going along, listening to nothing or something substantive, depending on what they're talking about. All of a sudden, out of the blue, like as if we'd never heard of it, this concept of a closed session. David Hudson once taught me the most important thing ever. I love it. He doesn't like to call them executive sessions. Why? It makes them feel too important. Closed sessions, not executive. I actually kind of like that from a granola roots protest kind of thing. What is the most, no, I'm not one of those, well, I was when I was younger, one of those lawyers. What has to happen, most important concept in the Open Meetings Act, has to happen before a closed session?
The vote must vote to go into it.
They must vote to go into closed session. I'm going to repeat. This is the #1 reason you can hang up a public official, public agency, and get the action set aside that takes place. If you figure out what happens inside a closed session, the public agency must vote in public while we are sitting there. Not before, not after. A vote must, it's mandatory. I'm seeing from the smiles that it's not happening. It must happen, and if you want to sue your public agency, call me up. I'll send you a complaint, because that is the #1 reason that, I don't even understand how public officials can do that wrong. It's
Go to
been in the law
polling right
forever.
after the meeting then.
So, yeah. Anyway, most important concept in the Open Meetings Act, the idea of a public vote to withdraw into closed session. All right. the reasons for closed session I'll come back to, just like I did for the exceptions for, we did for open records. As Jim pointed out very appropriately, and this is great, anybody remember Chief Justice of the Supreme Court, Norman Fletcher? He wrote a great opinion that I've never seen this done. If there is any doubt in terms of closing a meeting, do not close. It's in capital letters. It's a really nice opinion. The rule of thumb, just like all records are open, the idea is, which I know, that's why you're here, that can happen. Closure of meetings should be limited, and it should be narrow and just done for a very finite number of reasons. I will tell you in the code section also, take a look at this, because I've got the open meetings law written. There's less reasons for closure in the Open Meetings Act than there are exceptions in the Open Records Act, but I also know that that is abused. All right, let's say the vote happens, you and I are having our coffee, waiting for them to come out of closed session. Let's talk about a cross-check. How do you know what happens in closed session? And I'm gonna give Jennifer Farmer and the Georgia Press Association the biggest compliment in the world. The Georgia Press Association, years and years ago, even before my time, tried to get put in the law this idea of recording what happened in closed session. That was a really important thing. What happened in 2001, though, was nothing was happening in the law. We had no way to cross-check what happened in a closed session. This concept of an affidavit came around in 2001. An affidavit signed by the chairperson of the meeting, sort of a checklist of what was discussed during closed session. This affidavit is supposed to be filed with the minutes of the meeting afterwards, and it essentially is supposed to say whether or not the commission in closed session talked about personnel matters, whether it talked about pending litigation, whether it talked about acquisition of real estate. It was a checklist. That quickly devolved into a disaster, even though it still remains on the books. Some of the commissioners and public agency members did not trust one another. So that affidavit is supposed to be signed under penalty of perjury. What happened in some cases, some of the public agency members, or some of the public agencies had every member of the commission signing because they didn't trust each other that much. I will say this, that it was something. It was a start as to what happened in closed session. It wasn't, well, you tell me. I would say that it was an inadequate tool, but it was something. So the idea of what's supposed to happen is after the closed session happens, this affidavit is supposed to be signed, and when the minutes, which I'll come to in a second, are prepared and filed, wherever they're filed, this affidavit of what was discussed during closed session is supposed to be filed with the minutes. How then do you know that that was what was discussed? I mean, I asked you as a practical matter, how do you know?
Holly, I'll tell them real quick, something that happened last year in Clayton County. They went into a 2-hour executive session. The chairman and all the council members came back out in front, standing in front of the commission table, and the chairman, and this is exactly, I'm not exaggerating, this is exactly what was said. I'm not like leaving anything out. He said, "I will entertain a motion." And one member of the council said, "I make a motion to do what we discussed in executive session." The other one said, "I second," and it passed unanimously. And it's not, that is not uncommon. You know, y'all heard it too. It's not uncommon at all. And if there's one part of the act that I believe is more abused than anything else, it's the executive session privilege. And we'll talk more about that today. And then the segment that I cover in just a few minutes, we'll talk a little bit about executive session and how it is abused across the state.
So after this, after the public meeting, the idea is minutes to be filed. I would say in Georgia, and I have not looked at other states to see what they do, but the minutes need to record the number of the members of the public agency there, how they voted, the major pieces of business that was transpired, and along with the minutes that are filed, wherever they have filed, this affidavit of what happened during closed session is supposed to be filed. However, Jim makes a good point, votes. Even today, post the 2012 law, which I'll admit to you has confused me more than, well, I'm confused by some of the 2012 changes to the open meetings law. They don't make sense to me in a pragmatic way. So I don't understand why we're saying they're more clear. They've confused me more. But I believe what still stands is that when a agency comes out of closed session, any votes, although it's unclear if they have to say what it is they're voting about, they have to vote in public. And that's a rule of thumb when I have taught this subject matter over the years. If you remember nothing else, you remember that they have to vote to go into closed session, but any substantive votes, even if we don't know what they're about, always have to be done in open session. So remember that. They're going to get in trouble, as Jim points out, if they vote inside a closed session. Now, Matthew Cardinale, in his case against the city of Atlanta, tried to really get some specificity on what needed to be recorded, what a unanimous vote meant as opposed to a roll call vote. We could go into some specifics, but I would urge you to hold them to the concept of voting in public. Let me move on to two more subject matters, and then we can sort of come back to any questions you may have, or we can talk about them afterwards. Can a board meet by telephone? The law used to be that only agencies with statewide jurisdiction could do that, meaning the State Board of Transportation, the Natural Resources Board. Unfortunately, I think, now in emergency circumstances, usually for an emergency, you see why I hate that word so much, now a commission can do it only once. There's a limit on it, but it can happen so long as there is access, in other words, a call-in number for anybody who wants to participate. I am hoping that local municipalities and counties have enough ego involved that they want to be seen and posture and have things in person. But it is in the law now, so be aware of that, some of these local commissions can, at least once during the year, meet by telephone, so long as there is access made available for all citizens.
How would you know if it's an emergency meeting?
You're not going to know anything about an emergency meeting, that's the problem.
So how do you have access?
So, well, I can't, law doesn't go into it so much on whether it's telephone meetings for, just as a meeting once a year, I don't know. So let's not publicize that telephone meetings are a possibility. Let's keep it amongst ourselves and hope that the county attorneys, who are never happy to see me, don't notice it. All right, we'll talk about a couple of things that, again, confused me terribly. What are the exceptions to withdrawing to closed session? Well, all these crazy ones now are in it. You know, going to training, like here. Now, that's not a public meeting. I realize that it was impractical, but the County Commissioners Association and the Georgia Municipal Association lobbied for the idea that when they all go to county training, county commissioner training, that's not a meeting. When they go to a retreat, that's not a meeting. The old law used to be okay. It used to be, in my opinion, it was better, because the only thing we talked a lot about perception. If we're all going to my wedding and they're all there because we're celebrating my wedding, that's obviously not a meeting, because a meeting is something, and I'm sorry I'm out of order, you can tell I'm a little bit tired. A meeting is defined as reestablished, predefined to talk about subjects. If we're going to my wedding, obviously, let's hope that there isn't any reason that my wedding needs to be public. But the perception of them all sitting at the same table and such, that would be the problem. So the issue in open meetings used to be, well, was a meeting going to dinner before or after a commission meeting? Was that a meeting? But now, this is why I don't like the new open meetings. Like, there's all these weird new exceptions in it. This training thing, riding in a car together. And I realized that Jim and the Valdosta Times weren't gonna get in the van, or maybe you were, to ride with them to training. But all these weird exceptions that basically make it clear that these things aren't meetings. I thought from a public citizen perspective, it's better the way it was. In any case, there's a whole bunch of new exceptions in the Open Meetings Act that do not allow public access to things, and the retreats is a big thing, and training, so keep that in mind. We'll see how that shakes out over the next few years. I don't, as a practical matter, know when we're gonna get a chance to go back to the General Assembly to change this law. In some ways, we don't want to, because the problem with legislating open government acts is it can always get worse, but that's a policy discussion for another time. Remedies on open meetings. As bad as for open records, the same ones available, but I need help from you all, because I can't remember now. I believe the law used to be, if you filed a lawsuit within 90 days of the alleged bad action and you won, you can set it aside. I believe that is up to 6 months now. Is that correct in the law? Does anybody?
I think it's told based on the time that you learn about it.
That's from the time that you should have known about it.
Well, okay, I need to check that, but I believe the time limit is also now, there's a more, that was an improvement, a more realistic time frame. It's impossible to figure out whether you could put something in 3 months, no way. So that has expanded. But the same remedies for the open meetings as open records. The superior court litigation, which isn't practical or efficient. The criminal penalties, which are virtually never used. Stefan Ritter in the Attorney General's office. Me and Jim writing on the news media about these things. I will say that I have had more complaints over my career in this arena in open records as opposed to open meetings. But I will say the discussions about House Bill 397 which in 2012, which led to the new existing open government laws, most people at the table disagreed with me. They believed that open meetings had more problems. But I have always had a history of having more open records problems and complaints brought to my attention than meetings complaints. What else?
Well, we're gonna talk a lot about kind of the frustrations I think that a lot of us feel on the local level, and a lot of those do center around meetings and center around executive session. Thomas Jefferson called information the currency of democracy. And I will tell you something that is preferable over litigation, something that is preferable over transparency projects, over the First Amendment Foundation, over the AG's office, and over going to the DA, which by the way is a waste of your time. Local DAs are never going to prosecute anything to do with open government or open meetings. They won't even talk to you about it. They will always refer to the AG, and I've even had the AG's office say, have you talked to your DA? And it's a dog chasing its tail. But I will tell you something that's preferable to all of those remedies, and that is government just being open. We need to understand that it is incumbent upon a citizenry to realize that it is their government. And the only way that government can be of, by, and for the people is if it is before the people. This is not about us versus them, it's about us versus us. Because government, we are a self-governed people. That's the way our form of government, that's the way our constitutional republic works. It's the way that we have got to make it work. While Thomas Jefferson also said that if he had to choose between a government without newspapers or the media, or he had to choose the media without government, he would take newspapers and the media over government. But he also said that these principles of openness and transparency aren't about newspapers. It's not about the media. It is not the responsibility of the media. It's the responsibility of all of us. So let me do this really quick. Show me if you're a member of the media, if you're newspaper, print, radio, TV, whatever. So we have a lot of folks here that are media folks. And if you are a part of, say, a citizen action committee, a cause group, a watchdog group in your communities, and that is a good percentage of you. And if you are either employed by government or elected to office, and first of all, for everybody else in the room that did not raise your hand on this one, give these public officials a round of applause for being here and for caring about the principles of open government. We have got to get the dialogue away from us fighting government and make government realize that they are us. And I do believe that in every hall of government, on every city council, in every county commission, in every office in county and city government, there are good people who want to do the right thing. I believe there is misinformation. I believe that sometimes there is a sort of a misguided concept. And I also believe that there is a level of corruption that exists. The problem is, we want to paint a very broad stroke and assume that every time we get frustrated by government, that it's corrupt. And it may not be corrupt. It may just be wrong. It may just be mistaken. It may be that the government just doesn't understand something. There are a few things that I at least want you to take away today. And there are some things that I think that are going to be real important as we resonate the message back to our communities. And for those of you that are at newspapers or working in the media, or those who has a blog or a website, for those of you that have blogs and websites, for those of you that buy ink by the barrel and work at newspapers or any other media, let me tell you something. If we are not doing open government advocacy, we have sold our soul and we're not doing our jobs. And for those that believe somehow that it is a conflict of interest for newspapers and other media to do open government advocacy, you just don't get it. This is not about us. It's about representing the values of freedom. And if we don't stand up for the First Amendment and stand up for open government, we've totally misunderstood our role as the Fourth Estate. And that role is not just an important legacy and historical role, it is part and parcel of freedom. And I think that we have a pulpit, we have a voice, we have an opportunity every single time that we go to print or every single time we update our sites to be able to send a strong message to our community, to government officials, to those that are elected, to those that are working for government, and to just everyday men and women, to folks, that government belongs to the governed and not to the governing. So the first takeaway that I want you to have is, first of all, when it comes to, and I agree with Holly or David or whoever said that it's not executive session. And you know what? We had another word for it when I was growing up. Instead of closed meeting, we called it backdoor deal making. And I want you to understand that there is no requirement in the law for backdoor deal making. There is no requirement in the law for executive session. And that is one of the biggest misnomers by local officials. A couple of years ago, a reporter that was working for me went up to a chairman of the Board of Education and said, "Ma'am, can you tell me why y'all were in executive session for 2 hours. And the reporter sat there for 2 hours because she knew she'd be in trouble with me if she had left. Sat there for 2 hours waiting on them to come out of executive session. Do you know what citizens did during that 2 hours? They started dropping like flies. They started leaving, one right after. It happens every month, doesn't it? So the reporter sat there and sat there and sat there until she was sitting there alone. Except maybe I think there were a couple of spouses in the room. And so she goes up and she says, ma'am, can you tell me why y'all are in executive session for 2 hours? And here was the answer. We were required to. We had a personnel item and we were required to. Ladies and gentlemen, there is no requirement in the law to go into executive session for personnel. There is no requirement in the law to go into executive session for real estate. There is no requirement in the law to go into executive session for litigation. There is an allowance. There is an exception. There is a provision, but there is no requirement. So that every single time, local officials decide to go into executive session and conceal the people's business, they have chosen to do it. We need to send that message. Every single time they do it, they have conscientiously chosen to conceal the public's business. Now, I'm not saying that there are not times that that's a good choice to make. If, for instance, there is a potentially embarrassing or hurtful situation involving a personnel matter in local government, that might, for instance, damage somebody's children or hurt somebody on a personal level, it would seem reasonable that local officials would discuss the contents of that embarrassing information outside of the public view. But it's still a choice. It's still a choice they're making. If, in fact, somebody has their hand in the till, somebody is taking money that belongs to me and you, I don't want you going behind concealing yourself in executive session and disclosing that information. I want to know about it. And I ought to know about it because it's my money that somebody's been taking. If, in fact, and here's the thing that drives me crazy about real estate transactions. Everybody says the same thing about real estate transactions. We might compromise a deal if we talked about it out in the open. Really? I wonder how many times that's actually happened. Yes, a bad open meetings law gives them the ability to talk about a real estate transaction. It doesn't require them to. And I actually think if you talked about it out in the open, you might sweeten the pot a little bit. You know? And I'm not saying it would go that way, but it may very well be, by being more transparent and open about these real estate transactions, they can actually bolster the public's position in a real estate transaction. Because who are they buying that property for? What is government? It's us. So they're buying that property for me, but I can't know about it. They're buying that property for me, but I can't know until after they've already bought it. Yeah, they have to take the vote in public, but all the negotiations are going on behind closed doors. How many of y'all would buy a house or a piece of property and not know any of the terms of the deal until you went into closing to sign the paperwork? So yes, they can. But my point is, they don't have to. And do you know that not every state allows real estate transactions to take place behind closed doors? Every state doesn't allow it. So here's the thing. If you can buy property and sell property and lease property in other states and do it all out in the open, and it worked, why won't it work in Georgia?
It's usually who they're buying it from, not what they're buying.
How much paying for his relatives?
Well, again, I hope you take away in all your blogs and in your websites and on the front pages of your newspapers, or at the very least on the editorial page, that you let people know that it's not a requirement. There is not a requirement in the law. And, you know, I honestly do believe what I'm telling you. And that is that this chairman of the Board of Education 100% believed that she was required to go into executive session. She 100% believed that that was what she had to do. And I'm going to tell you why she believed that. Her attorney told her. One of your biggest enemies are going to be government lawyers.
Amen.
It is their intent to keep their clients out of trouble. My argument is, you're their clients. They're working for you. And that's one reason, and I run afoul of all of my legal friends when I say this, but that's one reason I don't really buy this whole attorney-client privilege thing. I am the client. You are the client. Government is not something other than the people. Government is the people. The second thing that I want you to understand is that there is no prohibition. I cannot tell you the number of times that I've gone to a member of county commission or to a chairman or to a mayor or to a city councilman and said, hey, help me out here. Tell me what y'all were talking about behind closed doors. And be told, Jim, I can't tell you, I'm not allowed to. I'd be in trouble. I'd run afoul of the law. I'd be breaking the law if I told you. I'd be breaking the law if I told you what we talked about in executive session. What I want you to understand is there is no prohibition. Our friend David Hudson, I think, fired a shot across the bow last year. And he made some public comments and conducted some interviews that we popularized. It probably did more than anything else really to grow and to put the Transparency Project on the map. And we had newspapers all across the state of Georgia pick it up and had people calling us right and left wanting to know about it. Sean Ireland at Georgia Press picked it up, and Sean said that very few things that Georgia Press had ever pushed out had ever gotten as much attention as this comment from David Hudson. And David said that the problem is that too many public officials misunderstand 4510.3. And basically what that law says is that a public official cannot divulge proprietary information or divulge information for personal gain. And David said, at what point can a local code of ethics, at what point could an affidavit, or at what point could your relationship to a commission or a council upon which you sit circumvent your First Amendment rights? Now, for a long time, I had a hard time understanding the relationship between the First Amendment and government transparency. And it always amused me because people a lot of times speak about the First Amendment, our freedom of the press and our freedom of speech and our freedom of religion and our right to peaceably assemble and to address government for a redress of our, petition government for redress of our grievances. And I thought, well, you know, we call freedom of information and government transparency the same thing, but this is one way that they are inextricably tied together. And that is just because somebody talked about something in the executive session behind closed doors, making a backroom deal, does not mean, if they believe it is in the public interest, that they are somehow muzzled and cannot speak to you, to me, to the media, or to anyone else. There is no sort of giving up of one's First Amendment rights simply by virtue of the fact that they sit on a county commission or that they sit on a city council. Now, good luck getting somebody to break ranks. right? Good luck getting a commissioner willing to come out and say, okay, Jim, I'm gonna tell you what, I don't agree with what they did in there, and I'm gonna spill the beans. But there are good people out there that believe in right things. And maybe all of us can work really harder to build relationships with government, so that every contact that we have with government is not adversarial. Every conversation that we have with the commissioner or with a council member is not combative. Because eventually somebody's going to do it. The very chairman that said to me, Jim, I legally can't tell you what happened, busted a case wide open in Henry County based on information that he shared about things that were going on behind closed doors that were done dirty. And here's the other question about it. How can somebody be legally prohibited from talking about something that goes on in executive session that is not legally privileged? And if you don't think that they're talking about things behind closed doors that they are not legally allowed to, you're naive. Because they are. Because they interpret the law in the broadest way possible. The state of Georgia says that the presumption should always be toward openness. Now you can take those words any way you want to. Here's what I think that means, and our lawyer can tell us whether or not she agrees with this. I think that means that the law should be interpreted as narrowly as possible. I don't agree with our executive session privilege, obviously, but it should be interpreted as narrowly as possible. A couple of months ago, I visited with Mr. Owens, and I've got a meeting with him on the 31st, on Halloween of all days. I've got a meeting with him scheduled on the 31st. And when we last broached this subject together, I told him I really think that we need to open up the discussion about executive session in Georgia. His response was, Jim, the climate in our General Assembly is fragile, and we don't want to open up this door. I disagree. The best offense is not a strong defense. The best defense is a strong offense. Open government advocates and the media need to advocate for ordinary people. And that's what this is about. And listen, if you think open government laws, if you think sunshine laws exist for the sake of the media, you're sorely mistaken. This is not a newspaper issue. It's not a media issue. This should be about the rights of ordinary citizens and their access to government. And the third thing that I want you to know is that there is no protection that is afforded just because a lawyer happens to be in the room. There is no protection that is provided local officials that is automatically triggered by the presence of their lawyer. The legal privilege says that they can go into executive session to discuss matters of pending or real litigation. That doesn't mean that somebody might sue us if something might happen. As a matter of fact, Stefan Ritter even said in a session at the Georgia Press Education Center in Atlanta last year that he believes that that means that there must actually be a filed lawsuit or a letter of intent to file a lawsuit. So that there has to be some piece of paper that suggests that a lawsuit exists or is about to exist, that the mere threat of a lawsuit or the concept of being sued is not enough, so that it is to be that narrowly interpreted. Listen, that wasn't, with all due respect to Assistant AG Ritter, that wasn't from an open government advocate. That was from government. And we need to understand that it is not up to the AG or to the DA or to Holly or Jim. It's up to all of us as citizens of the state of Georgia. that government belongs to us. So there is no automatic protection. I talked to a former mayor a few months ago, and he told me about one lawyer that served, I think, at one time, 6 different municipalities in North Georgia. And I don't know what else he did, but he served 6 different municipalities as their city lawyer. And I won't tell you his name, but his initials are Steve Fincher. And he said, Jim, I promise you that Attorney Fincher told the Hampton City Council, Joe Agee back here is from Hampton, he said he told the Hampton City Council, y'all can talk about anything you want to as long as I'm in the room. No, that is not what the exception allows. There's no automatic umbrella that is triggered by the presence of the attorney. Can I have that envelope?
Yes,
Did you read it?
yes, I did.
Thank you, this is mine now. Why did you give this to me?
Because it's yours. Because you own it. It was like a lost set of keys to me.
All the piece of paper said is this is Jim's paper. We need to stop begging government. How easy was that? You know why she gave it to me? Because she understood it was my property.
And she has integrity.
And she has integrity. Well, we allegedly.
You have no idea.
We are only asking government for things that belong to us. When you ask for a document, you're not asking government to give you their property. You're asking them to hand back to you your property that they're taking care of for you. Do you understand that concept? Now,
Sam Owens does that.
he doesn't.
No, he doesn't.
But I'm going to tell you, he's not alone. But that's the culture that we have got to incubate with our county, with our city, with our Board of Education. We're not going in there demanding something that belongs to them. We're just asking them, can you give me my papers back? Because we own the papers. When we want to know what goes on behind closed doors, we're not asking them to tell us something that belongs to them. We're asking them what they're doing for us because they're spending our money. They're making our decisions for us. Ours is a representative form of government. We do not elect officials to think for us. We elect them to represent us, and there's a big difference there. They are there to do our bidding. I don't think we have done a good job. You see, it's easy to blame the newspaper, and believe me, I'll put a lot of blame on newspapers. It's easy to blame the newspapers because they haven't been watchdogs. And I'm going to tell you, the newspapers in Georgia are not good watchdogs. Newsflash. We are not great at it anymore. We have left our mission of being the fourth estate. Let's just take ownership of it and admit it. We're not great watchdogs anymore like we used to be. But let's stop blaming newspapers. And let's stop blaming county commissioners and stop blaming city council and stop blaming AGs and stop blaming DAs and stop blaming records custodians and put the blame where it belongs, and it's square on our shoulders. Because we have not incubated an environment where there is the expectation of openness. Now, I say we in a very broad way. Some of you are doing that. But you are minuscule compared to our communities. When we build a culture, an environment across the state of Georgia that says, it's ours. It belongs to us. And we go into records custody. You know one of the worst things you can do? Hey, can you imagine driving up to the drive-thru at McDonald's and saying, I want my hamburger, I want it now, and I'm telling you I'm not going to wait 5 minutes for my hamburger. You put my hamburger here right now, and I don't want it to be cold. I'm telling you, give me my hamburger right now. Who wants to eat that burger when it comes out of the kitchen? But that's the way we treat government. I'm gonna tell you how, and Holly and I probably disagree on this, I'm gonna tell you how I think your first records request should always happen. Here's the way I think every records request should begin. Hey, can I have that for a second? Thank you. I think that's the way we ought to do it. We ought to be friendly, we ought to be nice, we're human beings. And you know what records custodians are? Believe it or not, they're folks. They're people. They're men and women, they're moms and dads, they're brothers and sisters and aunts and uncles. They're in-laws and outlaws. Some of them are outlaws, just a few. But let's just treat them with human dignity. And let's assume that they get it, instead of assuming that they don't. Now, when they don't get it, then we need to make that formal records request, and we need to build a paper trail. But the first time you really don't. The first time you really don't. The first time you just need to say, you know what? I was wanting the meetings from last night, and I didn't get them. Could you give me those meetings, or those minutes from that meeting? It's that casual, because all you're doing is asking them for what's yours anyway. And for the stuff they're doing in executive session, don't go in there and stomp and rant and rave and holler. Just say, what in the world were y'all doing back there so long? I'll tell you this one quick story, then we're going to break. A great reporter friend of mine was working in a case that involved a lot of open records, and was getting very frustrated because the records are being denied. They were being stalled. They were what's the standard response? We have no records
No
that are.
records responsive to your request.
That was it.
I
I mean,
can say that
kept hearing that over and over and over again, and was getting very frustrated. Came into my office, was, you know, saying expletives that we don't print in newspapers, and getting very animated. And I was like, okay, let's just sort of work through this, okay? So I picked up my cell phone, and I called the cell phone of the county manager. And I said, hey, Tommy, I understand there's an investigative file sitting on your desk. Could you get that over to me? He's like, Jim, I'm getting ready to go for lunch. I'll bring it over right now. It wasn't a battleground. But his office and his records custodian had stalled and or denied the record over a long period of time. I'm not saying that there should be an abracadabra, because there shouldn't be. There should not be any hoops that you got to jump through. There shouldn't be, because I'm the editor of the newspaper, I've got weight. Or because Helly, because my close, lovely friend Holly can write an amazing letter and has some weight coming from the First Amendment Foundation, or because I can call representing the Transparency Project, that we can access that record for you. It shouldn't be that way. And it shouldn't be that I have to be nice to get anything from government. But at the end of the day, our goal is not to say gotcha. Our goal is to get the record, to get access to me, and to hold government accountable. Okay, what we are going to do is we're going to break for 45 minutes or so, and lunch is on your own. That's the way, by the way, to explain to y'all that we were able to do the symposium for free, and I think that's the model that we're going to go after. We did this throughout the state. It looks to me like it worked. And there's all kinds of nice places to eat right here on the Strip in Mercer Village. This is a great venue, isn't it? And we'll come back in about 45 minutes, mill around.